It looks like we are ready to get started. Most of the attendees are in the call, so let's start with introductions. Today we're going to be doing a webinar talking about why sending preliminary notice to contractors is not easy and why CEOs rely upon professional lien providers to secure payment. With us today to talk about it, we have people from multiple disciplines. We have Hal Emalfarb coming in. He's general counsel at National Lien and Bond, and he runs the network of an nationwide network of attorneys to help with lien enforcement and collection. Regina Durand is with us, and she's the chief operating officer with Builders Notice Florida. Josh Fink is the regional manager with Construction Notice Services, covering California and the Southwest Coast states. Orion Gallagher is with us, and he's vice president of marketing for Construction Monitor. And my name is Anatoly Nirshberg. I'm with ParadigmNEXT, a marketing agency for the built world, as well as the National Association of Home Builders, where I sit on the board of the Chicagoland chapter, as well as the Global Opportunities Board. So without further ado, I'll hand the mic over to Hal to do the initial introductions and kick us off.
Okay, very good. All right, thank you for introducing the speakers. I'm very proud to present today a topic that I think is dear to the heart of many people that are attending, and that is how you can protect your receivables throughout the United States or in one state. National Lien and Bond was created around 1985, and for the last 35, 40 years, we've been philosophically working, even before the internet, kind of virtually, because we work nationally, but we actually think national or think global and act local. And the reason we do that then and now is because we like to work with professional notice providers. And in doing that, we have found the best ones that we thought were qualified for many years. And we have Josh Fink from Construction Notice Service and Regina from Builders Notice Service. And both of them have been working with us for decades and continue to do so. So I thought as automation starts to develop in the industry, we should be starting a conversation. How much of our project data should we look at it from an automation standpoint, and how much do we still need to look at it from an analytical standpoint where you have a hands-on approach? And the truth of the matter is, I think you need both, but as you're going to see right now, you can't do one without the other. You could do hands-on, but from an efficiency standpoint, I think you probably need both from that regards. So I think you're going to enjoy the seminar because we're going to get really into later on questions and answers. Anatoly will be taking questions. He might even, bring questions in at the appropriate time in between speakers or during speakers. He's very good at that. And thank you, Anatoly, on behalf of your company, the National Association of Home Builders. Appreciate your hosting and presenting the program and acting as the leader. So prior to your initiating lien notices, whether you're selling materials or installing work, 3 questions must be answered. And those questions are, what state is your project in? Whether or not your job is public, private, or federal, and how you can verify who the title holders are. And in doing that, if it's private, public, or federal, and getting that kind of information, that's very important. And the third question is, how is your company involved with the project? Are you a GC, a subcontractor, supplier to a supplier? What is your role? What is your tier coverage? Because you're going to find out in certain situations, you're going to need notices. I'm going to leave the examples of the notices and the steps and procedures to Josh and to Regina to explain the various states a little bit, to give you some background, and then I'll be giving you some examples, a little bit of some of the reasons why we really need this information and how come it becomes somewhat analytical, not automatic in every situation. So what happens is when you're looking at your contract role and so on, it gets a little bit, for example, somewhat complex, because a lot of times you're working as a subcontractor with a GC. Most times the GC is a third party. Many times the GC is the developer. Is the developer really the same party as the GC? Exactly. If that's the case, then there may be one entity developing it. Because when you're doing preliminary notices, and the reason why we say it's easy, it looks easy because you fill out a form, but it's not easy because you really have to think about what the consequences are. What we need to do when we get the notices and we do lien claims later on is we're, as legal counsel for National Lien and Bond, for many companies just like yours, I see some of my clients even on the seminar, what we do is we take the information that was brought to us in the beginning or brought to us after you've already sent out your notices. And we put them together in a story of how you're going to protect yourself and what actions you need to take. And if everything works good, you can look the developer in the eye and say to him, hey, please pay me, because if you don't, I may become the developer and foreclose on your property and kick you out. And we've done that numerous times, but not that anybody wants to go through the whole procedure process every time, but that's the purpose of lien laws. Now, when you're looking at preliminary notices, you really have to understand the generalities. And again, I'll let the speakers talk specifics. In a generality sense, if you're working with the owner, generally, but not in all cases, you'll find out that the owner knows how much the contract is with the prime or general contractor. If it's $1 million, they paid you $500,000. Guess what the balance is? Everybody knows, $500,000. If there's items in dispute, they know that. So in that situation, notices aren't as important to have. And in some cases, most cases, you don't need a notice when you're dealing with the owner directly. Not all. That's why you have to check in every situation, but in most. Now, if you're a subcontractor, not in privity of contract with the owner, in almost every one of those situations, in about 25 to 28 states on private jobs, and about this a little less on public jobs, you do need to do a notice because the owner doesn't know who you are, or sometimes in a public job with a bond claim, you have to notify the general contractor. Because again, if you're a sub to a GC, let's say like in Georgia, you don't really have to give a notice. But if you're a sub to a sub, not in privity with the GC, then you do have to give a notice. So in all 50 states, I mentioned to you before, you have to determine what state you're in. If it's public, private, or federal, there's a statute for each one of those situations. So 50 lien laws for private, 50 bond claim laws, about 26 lien on public fund laws, and one federal law called the Miller Act. So I don't know how many people are doing federal work, but really with new programs coming out in infrastructure, you've got to kind of be ready for looking at that and getting ready for that type of work, because it's definitely going to be here. I think it's going to be kind of important for you. So the interesting part about all of this, and we've got Orion, who's going to speak in a few minutes. Orion Gallagher works with Construction Monitor. Orion, we're lucky to have him today as a speaker because his company basically captures building permit data. Why is that information important? Because when you come to do your notices, okay, through National Lien and Bond and its providers, such as Builder's Notice or Construction Notice Services, you'll see that the information that they need is what is your name, what is your customer's name, how much is your contract many times, when did you start work? On NLB's form, we're a little bit longer because we need to know when do you anticipate starting work and when are you going to finish work, because we're kind of monitoring many times for our clients who are suppliers and subs who do business locally and nationally. We're mostly working with national companies, but we do quite a few local ones in conjunction with our offices in all 50 states. You may not know this, but in 1985, we put together one lawyer in every state who summarized the lien law. And I learned back then a lot about lien laws in every state. Fast forward till today, we've coded these steps and so on in spreadsheets and in software. And all I can tell you is we know, all of us as lawyers, our state very well. And so we know the lawyers in the other states who know their states very well. When I try to remember every step in every state, it does get, even for me, who's been doing this for over 40 years, a little bit complex. So it's very important for you to know that just filling out a form isn't the way to, take your notice yourself, or even with one cloud automated company or another who does it nationally, because you're not going to get into some of the problems. So I kind of want to demonstrate a little bit. Let me see if I can share my screen for 1 second with everybody. Let's see if I got any new emails since the last time I did this. Hold on 1 second. Yeah, here we go. So on this particular project here, this is a subdivision. Can everybody see the screen? All right, great. So in a subdivision, let's say you're doing work in one of these lagoons or one of these water areas in between that's not owned by anybody specifically, let's say, or it's owned by a developer, but look at the lots surrounding it. So when you're doing subdivision work, what you have to do in this kind of situation is you have to say, okay, if I'm doing streets or sidewalks or sewers and things like that, where does my lien apply? How does my lien get filed, and who does it get filed against? So when you're filling out the form for the notice services and for later on for lien, you need to know, and that's one of the things Orion has some information for, but Orion's information, even Orion's information, while it's probably accurate, is not complete, which I'll explain. Because when you're looking for who the owner is, what shows up on your contract, what shows up in a building permit may not show up, as I'll demonstrate in a minute, on the recorder of deeds office. So it's important for you to see when you're sending your notice out for one lot, it's pretty basic, but if you're doing it for the whole subdivision, you have two choices. You can either allocate the whole lien on all the subdivisions for one amount, or divide the lien up by, let's say there's 200 lots here, by 200 for each lot. So Florida law and other state laws are different from each other. And some people don't even allow you to have liens in subdivision improvements because that's like a public street being improved by a private person. So it gets a little complex when we're looking at these situations. And that's why we ask the questions we do. And the automated programs that are becoming popular to use today aren't asking those same questions and don't really even know what questions sometimes to ask, particularly. So now let's look here. Here's another situation. This is, does anybody recognize this building? A little bit. This is in Brooklyn. And the location it's in is the old Brooklyn Navy Yard. And the old Brooklyn Navy Yard, you can see the piers. This is Pier 72. This is where the warships were in here for the Navy. Well, today we're reconverting a lot of property. The federal government, as you can imagine, since it was the Brooklyn Navy Yard, was the original owner of this property. And then in the 1970s or so, they deeded, or 1980s, the city of New York. Then the city of New York deeded it to an economic development agency. Now, why did they do that? Well, one reason is you cannot build on the fee of city property unless you're the municipality. And if you're doing business on a public job, you cannot lien the actual city property. Now, I learned that lesson once in Chicago when I was looking to file a lien for a concrete supplier in my young career when I was about 30 years old. And the judge said to me, do you want to be held in contempt, Mr. Emalfarb? I go, no, Your Honor, I'm just trying to get my client paid. He goes, remove the lien, file a public lien on funds. You cannot lien the real estate of the city, but you can lien the funds in Illinois and in New York, coincidentally, and about 25 other states. So in those states, you can file your notices and liens for a remedy called lien on funds. Because all this information that we gather, what state is it project in, what type of contract is it, what is your role in the project, what are the dates you went to work, who are the parties that you contracted with, who are the parties entitled, all that analysis has to come together to determine what your actual remedies are. So in this situation, we had a client that did some work as a subcontractor for a GC. And with the last pandemic, the retention wasn't being paid. So we filed a lien with the Kings County Recorder of Deed, and we listed, because it was accurate, that the city of New York was the actual owner of record. The Kings County clerk, 2 weeks later, rejected the lien, saying, no, you can't lien city property. I go, here we are again. I was told that in Chicago. Now I'm being told the same thing in New York, but it's not owned by the city. It's actually owned by this developer that built it. What's the difference between a property that the city does, such as a fire station, such as a courthouse or a water plant, and a situation like this? The difference is that the city here deeded the property to the Brooklyn Development Corporation from the city of New York, and they did it through a lease. When they did it through a lease, they then went ahead and went for an RFP, attracted the business with the developer, and then they ended up creating another leasehold on that property with a developer. And in doing that, I think, let me see what this is. Yeah. In doing this, what happened was all these leases went forward, and here was the lease between the city and its own development company. Then there's another lease between the development company and the developer itself that actually did the project. The reason why that's important is because when the developer did his project here on Pier 72, he leased the property. So we had to go back to Kings County Clerk's office, redo the lien, show the developer's property there, and mention in the title description accurately that this property is part of the same property owned by the city of New York, but we couldn't lien the city of New York's fee. So what did we lien? We didn't lien the fee, we liened the leasehold interest. So when you're looking at the questions, again, you also have to look at interpretations of who's entitled, how is the property structured, and understand these various levels of complexity. we happen to do that because in practicing this area for 40 years, having experience as a developer, we understand very much how properties and zoning and planning and subdivisions and recordings work. So you have to really put a real estate cap on in order to effectively create a lien by doing your steps that are required here for preliminary notices to protect your receivables, because you got to look the developer in the eye. And we're doing that today with a couple of jobs and saying to them, hey, listen, you're not paying our client. And you know, take a look at your loan agreement, because we understand loan agreements. You are a developer, you sign a construction loan agreement that says you can't have any liens. It also says you're supposed to use the money on the job. And then you're also supposed to pay immediately once you get paid. Did you pay that general contractor? Oh, you did. Well, did you know he didn't pay us? Oh, you didn't. Well, now you're in violation of your construction loan because now you know that. So please stop paying him and we're going to do a lien. And the reason why this becomes important is that once you do your preliminary notices and your liens, many of us are experiencing a trend, which is kind of frustrating a little bit, where developers and general contractors love to do what's called bond over your liens. So if you don't get it right, you've got a lien that's been bonded over, and then they're going to try to discharge your lien, fight it in court, and you're going to end up with nothing. If you do it right, sometimes a bond over lien is a little easier than filing a complex lawsuit with 15 people like in here. But at the same time, it's important for you to understand that the process is very, very complex sometimes. But if you keep in mind the main goal, you want to get paid. If you don't get paid, you want to own the property and sell it for money. Because if you don't take that attitude to negotiate, what NLB has developed over the last 40 years is a formula for payment that requires the partnership of everybody that's on this screen, plus 50 lawyers in 50 states and sometimes more, because we put together whenever we have a situation, whether it's a preliminary notice mechanism to help you internally manage your preliminary notice requirements and put you in touch with the right people to do it at affordable price and efficiently. We call them professional notice providers, such as Josh and Regina here today. Then what happens is you get the protection of that. So what we call the formula for payment, it's transaction, which is your agreement and your ability to do your notices, plus leverage, which is the power of the remedies that you get, equals payment. So if you have a perfect transaction, you fully performed your job, follow the laws correctly, you've got a very good chance of collecting 100%. And when you look, I was talking to Regina and to Josh a little bit, looking back at the last 20, 30 years of our relationship. And we've added up, I don't know, several $1 million worth of projects. I don't know how many billions of dollars. And most of the money, when you send your notices out and you do, if the very rare situation that becomes more collection or legal, most of it is just working things out. When you actually add all these numbers up in value, and as we start having all this data and exchanging information, you'll see that you're getting paid close to 100% of your money. Now, that's not in every job and not every situation, but again, it all starts with step one in the project data to move forward. So what I like to do at this time is give Josh an opportunity to talk about construction notice services, their background, and they're in 7 states, and Josh will explain where they're at. And, you know, I think it'd be great if he would give us an example of what kind of data is he looking for to get your preliminary notice started, and how can we go ahead and take the steps to get people in the position in the states that you represent, Josh.
Great, thanks, Hal, for that introduction. As you mentioned, my company, Construction Notice Services, we're located in the Western United States, operating in California, Oregon, Washington, Nevada, Arizona, and New Mexico. One thing that stood out when Hal was talking was the first question he asked is, what state do you operate in? And that's obviously the first question we ask as well, mainly because it comes down to time frames. These prelim notices, known by different terminology throughout the country, notice to owner, notice of right to lien, they all center around timeliness and the need to send the notice, whether it pertains to the start of the project. So California, our biggest market, for instance, you have to send the notice within the first 20 days of starting the project. And besides knowing what state you operate in, there's only a few other pieces of information we need in order to process the notice and secure your lien rights. That being, we'll need to know who you're in contract with, what your scope of work is on the project, what the job address is, and a contract value for the work that you're doing. The reason we ask for so little is because we take the time to do the research and to flesh out all the information that Hal was talking about, specifically with that Brooklyn Navy Yard, finding out who the actual owner is, finding out whether it's a leasehold agreement or not. We do all that legwork up front so that it doesn't have to be done later on when you're filing the actual lien. Our belief is if you send out the most accurate notice possible, it's going to protect your ability to record a lien and also get you paid faster. The general contractors, they're sophisticated. They know those subs and suppliers who send the notices, they're going to pay them first. If I was a general contractor, I'd do the same thing. If I know that ABC Supply sent a prelim notice and the concrete supplier did not, I can string the concrete supplier along a little bit longer because they did not do the prelim notice to secure their lien rights. So that's where our research comes in. We have a team of 40 researchers here. We send out approximately 80 to 90,000 preliminary notices a month. So even though we're a smaller player on the side of things, not national, we're still large enough to get the volume of notices needed to obtain all the information to help every one of our customers. So within our organization, we're sharing project data with all of our other customers so that if one contractor is working on 123 Main Street and we've done a preliminary notice for them, all the other subs working on that same project will be able to have that up-to-date information. And as Hal mentioned earlier too, the project information that you might obtain through the building permits or through a previous notice, all that is in flux and it changes so frequently in construction. For instance, if you're working on a project where there's an owner builder, are you really working for the owner or has he sold that parcel to a new buyer? That happens all the time with these developments. So these are the things that through finding out all the information necessary to make sure that these notices are done on time. That's where we're able to catch those small mistakes that, larger just basically type in the info and get it sent for your companies aren't able to handle. And just sending them preliminary notice is good, but it might not be good enough. And the only time you find that out is unfortunately when you're not being paid and then we have to go file a lien and maybe you have the job address wrong or the wrong property owner and you're stuck, holding the bag, be able to file that lien and you have to go to more expensive times, extensive remedies to try to collect the money that's owed to you. And it's just working with a local provider, and I'm sure Regina will be able to speak to this as well. We know the ins and outs of our local area. We know the county recorder's offices. We know when we get some information that looks a little funky, maybe a county doesn't add up to where the city is. Because we're local, we know those things, we're able to catch that. Where if you're working with somebody who's trying to research these notices and they've outsourced the research overseas or something like that, they're not going to catch those mistakes. So really at the end of the day, what are you paying for? And we've been in business since 1984. We have 37 years of history, most of that time partnering with NLB to kind of work together to make sure that we'll get the notices done and then they take it more on the legal side of things. One of the things I wanted to note also about the county recorder's offices, for instance, in California where we're located, they just opened up yesterday. And so for the past year plus since the pandemic, we've been able to electronically record documents with all the 58 county recorders offices in California. And I know a lot of the national lien filers weren't able to do that. So what does that mean though? Well, in California, you have 90 days from completion of the project to file your lien. And so if we're able to electronically record documents, that cuts our recording time to about 1 to 2 days. What people weren't able to do by not walking into the county recorder's office to record the document was they would have to send it by mail or FedEx. And we were hearing stories of it taking 2 to 3 weeks from the mail being delivered to the document recorded. So that means that if you decided to wait till the 80th day to file your lien by using one of these national, just type it in and send it services, your lien timeframes have expired. They've gone past the 90 days and it's too soon to know what the courts will do with that information, but I'm not trying to risk it with my customers, money that's owed to them. I'm not trying to risk it with a court case to say, hey, judge, it was a pandemic. Can I get some grace period? We don't know how that's going to fall out. So luckily our documents were able to be recorded, and that's with these local relationships that we've built over our 37 years. So that's just a little bit of what we do here in the Western United States. We very much pride ourselves on customer service and the research to make sure that the information we're putting on these notices and liens is as accurate and timely as possible. And once again, we work not only in California, but Washington, Oregon, Nevada, Arizona, and New Mexico. And I know Regina here works in Florida, so I'll pass it off to her. She can kind of go into more detail how her company works and what you guys need to look out for when working in Florida.
Very good. Thank you, Josh. Yes, my name is Regina Durand. I'm from Builders Notice. Builders Notice has been in business for since 1975. So we've been in business for a while. We're one of the oldest companies on Florida. And as you know, Florida is one of the toughest states. But we do have one of the, I believe, to have one of the best construction lien laws nationwide. I wish everybody will have the same law so we all can work together. In Florida, to protect your lien rights, as a supplier and a subcontractor, you must file your notice to owner within 45 days of your start date. But the sooner the better, because the sooner you give the owner the chance to monitor your payment, believe me, it's gonna work on best for you. Then after that, if something goes wrong with the job, then you have 90 days to file your lien. But I tell my customers, they don't pay you by 60 days, chances are they're not gonna pay you by 70. So by 70, 75 days, you should start making a business decision on what to do next. Notice to owner does a couple of things, excuse me, improve your cash flow and also protects your lien rights, okay? So when you send the notice to owners, like Josh was saying, you get to get paid first because the contractor, the owner, the lender, they know that you're there, that you're legally gonna pursue it. So you wanna make sure they're gonna pay you first. So that improves your cash flow. It's also a good communication because you let the owner know that you're there and he's gonna make sure that you get paid because otherwise he's gonna be responsible for your payment. Now, there's a notice of commencement. Notice of commencements are one of the sources, one of the legal forms that we rely. I wouldn't rely 100% these days, but there's a legal document that we can rely to establish the notice to owner. It's the owner's responsibility, and if the job is bonded, it should be attached to the notice of commencement, okay? That's one of the things that we do. I believe each state has different laws, and as we've been in Florida, we can guarantee you that we are gonna cover with our experience. Our researchers have been with us for over 20 years plus. And between the tools that we have, we are connected with the title company because these days, public records are not 100% reliable. Maybe Josh will tell you that too. So we have to use all different tools to make sure that we notify everybody that needs to be notified to protect your lien rights. As you know, the problems are never at the beginning of the project. They're gonna be at the end of the job. And by then, you're gonna turn around and see that your notice wasn't done properly, and then you're not gonna be able to go against the owner. So I'm sure there's other legal recourses that you can obtain, but filing the lien, I think, is one of the best options under the construction lien law. Okay. One thing I want to emphasize is the releases. I'm sure Hal is going to be talking about that, but releases are very important. I always emphasize to my customers, gotta be careful. You have to make sure what you're signing. If you're not getting paid, make sure there's a conditional release. That way, if something happens to that payment, that release becomes null. Partial releases is something that you have to be careful. The true date is very specific because once you sign that release, you're not going to be able to go against the owner through that date. One more thing I want to establish is that my company, like I said, it's been in business for so long. That's what we do. That's all we do. Notice to owner construction liens through the attorneys. We've been working with Hal for, like he said, many years, and we believe that it has worked for us, and he believes that Florida or like California and other states that Josh managed are better handled when you are local and you know the law and you are be able to protect it the best. So again, I'm going to leave you with Hal, And I think if you have any questions, hopefully we'll provide you with my email, and I'll be here to serve you. Okay, thank you so much.
Regina, thank you very much. And Josh, thank you. What I'd like to do is, Regina, if you don't mind, before you finish,
Yes.
I would like you to explain what is a notice of commencement, what is its purpose, and how does it relate to what you're doing?
Okay, well, the notice of commencement, is one of the source documents to perfect your lien rights. Okay, it's the owner's responsibility, but a lot of times the contractors like to file that to expedite the process. But again, if something happens to, for instance, you're doing a job and the owner didn't file the notice of commencement for whatever reason, then, and you have to file your liens are gonna go priority to the lender if there was a lender on the job. If there was a notice of commencement, then your lien comes after the lender. Okay, so it's very important to know if the job has a notice of commencement. Also, when the property is sold in the middle of the progress of the job, then if there's a notice of commencement, you're gonna go back to the first owner and then also the new owner. But that's what it does. Then once the job is completed, you can do a notice of termination. I mean, the contractor and the owner will do a notice of termination, guaranteeing with the affidavit that all the subcontractors and supplier have been paid. And then if that's the case, notice of termination will be filed. It will be sent to all the vendors, all the lienors, and then the time gets reduced from 90 days to 30 days to be able to go after the owner. So it's always make sure that you, anything that you receive certified made by the owner, make sure to review those documents because it will reduce your time. But the notice of commencement, again, is something that is responsible, the owner is responsible. Not the sub, not the supplier, not the GC, it's actually the owner's responsibility. Yes,
So Regina, on the notice of commencement, you have the owner's name, correct?
Correct. I mean, on the notice of commencement, the owner is responsible and they need to be filled out with the owner's name, the legal of the property, if there's a lender, if there's a bond on the project, who's the contractor, the type of services they're gonna be providing on that project. Normally, the notice of commencement lasts 1 year, but if the job is gonna be longer, they can amend the notice of commencement or they can actually put the expiration date if they know how long it's gonna last.
Yeah, so that information is very important, that kind of project data. And a lot of it's right there. It's kind of like a bulletin board where you have the notice of commencement. Now in Florida, you have your first step, which because we're talking about here, the preliminary notices are not always that easy, to prepare. The first step in Florida is basically the fact that the 45-day notice has to start at the first day to work. What happens if somebody doesn't send a notice out within 45 days from first day to work in Florida?
Well, they lose the lien rights. I'm always going to recommend send a notice because at that point you want to get the owner's attention. But if you don't do it within 45 days, and as a subcontractor, 45 days from the first day of the job, as a supplier, it's 40. If you fabricate the material, it's 45 days from you start spending time and money into the product. It's not when you deliver. Is when you start spending time and money into the product. So 45 days to protect your lien rights. If you don't do it within 45 days, then you have the owner's not responsible. Hopefully the job is bonded and you're working for the GC and then you can go after the bond, but that will be the case.
So the 45-day notice for a sub is when they start working. If it's a normal product, it might be like lumber, it's when they first start delivering. But if it's special fabrication, like you're mentioning, it's 45 days from the start of fabrication.
Correct.
And these are the little tidbits, that local providers live with every day. And it isn't so much understanding that these are the rules. The question is identifying when you get the form filled out, the simple little form that you fill out for the project data sheet. That's only the beginning. What both Josh and Regina mentioned, and that's what we like about our dealing with professional notice providers, as BNS and CNS and the other people we work with around the country. We put together a network of people that don't just take the form, don't autofill another form, and don't ask the questions. Because what you need to do is ask the questions in this kind of environment. And that's really something that has impressed me always. Now, Josh, in your state, Regina mentioned 45 days from first day of work. What do your time period is what again, and how does it differ?
It's 20 days from the start of the project. And where California differs from Florida is if you are late, you can still send the notice and have some lien rights. The way the notice works is it backdates 20 days. So let's say you start work on March 1st, but you don't get your notice sent until March 25th. You're not dead in the water like in Florida. You will still have the ability to record a lien, but you won't be able to claim on the mechanics lien any money that is owed to you for the work done that was done on that March 1st through 5th date, since you're 5 days late on the notice. So whenever you send the preliminary notice, just know that you, in California, you can only claim on the mechanics lien 20 days prior to when that notice was sent to be able to fully collect. So hopefully in that first couple of days, if you are late, there wasn't much work done. But if you're only on the job for 5 to 7 days and you are 4 or 5 days late, you might not be able to collect very much via mechanics lien.
So, we've been talking a lot about mechanics liens, which is, mechanicslien.com is our website, but our website is also paymentbond.com and milleract.com. And both of you do notices, not only with mechanic liens, but on public jobs contracts, which are payment bonds, and federal jobs too. So I want you just to spend, like, if you can, 30 seconds each talking a little bit about your experience on payment bonds, because what I see today is a lot of private jobs have payment bonds, and all the public jobs are required by law, whether federal or state, of any given size, they have a payment and a performance bond as well. So some states have, as I mentioned before, like New York and Illinois and some other states, a lien on public funds, but you can't unless you want to go to jail, and 3 times the charm. So I'm trying to stay out, okay, to make sure that I don't make any more, get the next judge mad at me. They don't have a good sense of humor, because as Josh and Regina and I have been going through, the legal system, the recording system, I mean, it's really been impacted, and it's really been difficult. And because of our expertise, I mean, it took me 2 weeks to get something done in Kings County. And I know everybody in the Kings County Recorder of Deeds, all their desks, their files, and what they look like, okay? But I couldn't get into the building, but we Zoomed with them and pushed them until they finally got what was there. But it's hard, it's not easy as it sounds like, and it's not as simple as filling out a form. So let's give our listeners a little bit of education, because I think what's important here is that, a lot of times either Josh or Regina will send a case to us that's not within their territory, and then it's very hard for me to explain, hey, in Florida you do this, in California you do this, so I'm gonna do the same thing. Well, I'll tell that story in a minute about how that just doesn't work, and how we have to educate people after Josh and Regina have them understand exactly what the process is in their state. Then they start going to the other 40 states or 45 states. So Regina, if you could talk a little bit about bonds, and
Sure.
then Josh.
Okay, I'll go first. All right, yeah, that is true. I noticed also, more and more these private jobs are required to be bonded in Florida, which I think is good in my personal opinion, because now you have 2 ways to try to go after. So here, when we do the liens, we'll do both at the same time, the lien and the notice of non-payment, because it might go either direction. Most of the time, it's going to go after the bonding company. A supplier working for a sub that is working for a GC, they must have that notice to owner to have any bond rights. Okay, subcontractor working for the GC on a private job, obviously should do a notice to owner to protect the lien rights, but if they don't have the notice to owner, they can still go after the bond, and they still have the 90 days to go after, to file. What we do first, we file notice of non-payment, which is just the first step, where the bonding company will normally send them within 2 or 3 weeks, we'll send in like a claim form to fill out, to start investigating on that payment. And then they do have 1 year from the last day of work to go and do that demand under the bond, But on public jobs, same thing. Supplier working for a sub is working for the GC, they must file notice to owner to protect that bond rights. They're working for the GC, they don't have to do a notice to owner, but according to different attorneys that I have talked to, they think it's a very good practice, they should do it. Josh?
Yeah, very similar process to what Regina explained. Send the bond claim to the surety company, and then they'll come back with paperwork that our customer will have to provide showing evidence of their claim. One thing we do is we also send a copy of the bond claim to the general contractor, because a lot of times when these GCs have bond claims against them, it can affect their ability to obtain a bond in the future, which could hurt their ability to bid on certain public works jobs. Also, we're seeing in California a lot more private jobs having bonds obtained on them as well. One thing that's unique to California for state jobs is what's called a stop payment notice. And it's kind of an expansion on mechanic lien law, but for state projects. As Hal mentioned earlier, you can't file a lien on publicly owned land because you can't foreclose on the public. So what the state of California has implemented is a stop payment notice, and basically you're liening the funds that have been allocated for the project. And so in that case, we would send a notice to the state agency who's managing the project. Let's say it's a college, like UCLA, for instance, is building a new dormitory, and you're not getting paid on that project. We'd file the stop notice with UCLA, and then they, by law, have to stop funding the general contractor up to 115% of what you're owed. So that's really going to be a big headache for the general contractor to be able to move forward with the project with those funds missing. Very effective, but has the same notice requirements as a mechanic's lien, which does make it easy to manage, because whether you're working on a state or commercial residential project, everything starts with the initial notice. Get it done within the first 20 days so that you can have some sort of remedy to collect.
All right, great. So now I'm going to introduce Orion Gallagher of Construction Monitor. And Orion's company does, as I mentioned, their primary business is providing companies like yours the ability to provide a lead for you to market your products. And Orion can explain this company a little bit more. When we're done with Orion, I want to give one example of what happens when you're not in the territory that Josh is in, and what happens when you're not in the territory that Regina's in. And sometimes they send me, or we get directly from our other clients, claims in other states. And we recently had one in New Hampshire. It's kind of a funny story that I'll explain to you. But let's hear what Orion has to say about his project data and how maybe we could use it not only for leads for business, but how we can use it internally here for credit.
All right, thank you for the introduction, Hal. I'm going to go ahead and share my screen, actually. Hal, it actually won't let me share my screen. Do you have to give that to me? I believe you're muted. Anyway, so I'm with Construction Monitor.
The host, that would be great.
I'm sorry, what was that?
I'm saying, Hal, if you can make Orion the host, then he'll be able to share his screen.
Anyway, I'm with Construction Monitor, and since 1989, we collect and database building and solar permit data throughout the United States. We update on a weekly basis, and the reason Hal invited me to this call is that the permit data is useful not only for leads, but also for identifying who the general contractor is, developer is, et cetera, on any of the projects that we track across the country. So there has been times that Hal has not been able to easily recognize who the general contractor is or architect is for a project. I can look up the permit data from Construction Monitor and then provide that information to Hal or to anybody else. Now, in addition, of course, it does provide you lead information, because you would be able to see who is building what and where, as well as their contact information. And so that could be very helpful for your lead generation as well. I'm going to share my screen really quick. Okay. So up on my screen, I actually have Construction Monitor's website. It is software as a service where you're able to log in and search for whatever project data you have access to. So, and I know for sake of time, I'm going to go through this really quickly, actually. So just going to log in right here. And I know we've been looking at Florida and California, so I'll just go ahead and pull up some single family home data for Florida. I specifically saw Lennar earlier as well. So if you wanted to see what Lennar Homes is doing in Florida, pretty easy. Just go to the power search. I am going to blow through this, but if you did want to find out more information on us, you can just go to Construction Monitor's site and request a free edition. But there's a power search, and we're going to do a single family home search for the state of Florida. And I'm going to go ahead and sort this by go by date. Okay, so very easy. And then up here at the top, you could search by company name, or you can also search by address. So if you're trying to identify who the general contractor is on a project that you've done work on to, file liens or whatever, you actually can search by address as well. So Lennar is pretty dominant in Florida, as everybody knows. 4,023 single family homes that have their name on it. And you can see from this bird's eye view where these projects are, but clicking in further, and this is what I show with Hal all the time, you could see exactly where these homes are being built. You can even see them, in the construction stage right here. June 9th, 2021 was when the permit was pulled. Shows you the evaluation of the project in building materials only, the exact address, including zip 9. We had the zip 9 for the geocoding. And then in this case, contractor owner. Now, really quickly, I'm going to go back and do another quick search for like a commercial project. So let's say you're trying to see a commercial project that you've worked on in Florida. Let's see if I can get a big one as an example. Because I would say the commercial projects are a little bit harder sometimes to identify who is actually the GC architect on a record. Let's modify this and go by value. So we'll do $1 million and up. So we got like, let's say this warehouse building. So it gives you information on the owner of the warehouse, the contractor that is the GC, and again, where this is going to be. So if you are doing work on this project, then you'll know who the contractor is, who the owner is. If you haven't been able to find them before, again, you have the exact information. So if you wanted to, if you know you're working on this address, you just simply type that into the power search and it'll give you information on who's actually doing the work. So again, for sake of time, I want to make sure that I close this off so we can get Q&A. So I guess that'll close out my section. So appreciate the time. Thank you, Hal, for having me.
And Orion, and I want to thank you very much for showing that. And as Orion mentioned, we've been working together for several years too, understanding his technology and how it works. And it's fairly accurate. I want to caution everybody, including the notice services, though this information is accurate, it may or may not be what you need to put into a notice, because the legal owner of record may not be Villa de Sol LLC. It may be another name or a partnership. This might be the development company, not the person in title. So that being said, it's a good start in putting the information together, particularly when you don't have it. And Orion's service has been great in establishing that. One of the things that I think that has been pretty important for us a little bit is that we have had many people calling us up saying, well, we just want to fill the form out. We just want to send out the notice. What can we do? Recently, I had a several $1 million contract, could be 200,000 or 20,000. The number doesn't really make any difference. We obviously pay a lot of attention to the situation where there's a lot of risk. We want to just, take every step possible that we can. But what happens is that this situation came in, it was a job that came from Florida, and it was working in New Hampshire. And I haven't worked in New Hampshire probably, I would say, in 10 years. So I had to refresh myself on what was going on in New Hampshire. So here's how New Hampshire works, because I want you to see that the states are completely different almost. There are some similarities, but we look at the similarities and distinguish the differences. So in New Hampshire, unlike Florida, unlike California, but similar to Alabama, for example, and similar to Virginia, for example, because they have a similar situation, you have to provide a notice if you want a full price lien before you start work. And in that situation, that's called a notice of lien. And I was arguing with a subcontractor who said, well, I don't want to lien the job. I just want to do a notice. I go, well, they call their notice, if you want a full price lien, notice of lien. And that's kind of a interesting situation where you basically have a client that you're trying to educate. because they're used to doing what's going on in Florida, which you're hearing about, or what's going on in California. And then we have to take them and hold them by the hand and educate them. Because what National Lien and Bond does primarily is we put together the team that works with us around the country, but we also provide the education and the compliance steps and requirements. Once you have an understanding of it, you can do it on your own, but you have to understand how it works. So after you do a notice of lien, notice of intent to lien, and then you've got to give every 30 days, believe it or not. And this is true in Texas and like in Tennessee and a couple other states. Then you have to give a monthly notice of a statement of account. Well, it kind of blew my mind because I haven't been there in a long time when I went through this whole process with them. But for $2 million, I explained to the client, I think we have to make sure, you know, that our office in New Hampshire, you have to follow their steps and do it the right way. And sure enough, she filled the information out, partially correct on who the owner was and partially incorrect. So the notices, if we allowed ourselves to believe her form without taking, just like Josh mentioned and Regina mentioned, and how Orion is demonstrating here, if you don't put all the pieces together, make your analytical decision, put a hands-on approach, you may not end up with the right information. And you think you're going to get paid and you find out you're not. And we've learned that many, many times when a national company comes in, they don't take the extra step that's needed because they're not really sensitive or familiar with all the exceptions. Some of the things here today you've heard, which is a little unusual, such as the notice of special fabrication, which is abundant in Florida, as Regina mentioned. Your notice of 45 days goes from date of fabrication. That's also a requirement in Texas. And the reason for that is if you want to file a lien, and especially fabricated, and you want to make the owner pay twice, and what's going to happen is for the owner to pay twice, they want to make sure that you tell the owner up front everything that's going on. Because if you don't tell the owner up front, it's unfair for them to have to pay for specially fabricated goods, and it's unfair for you not to get paid. So there's a mutuality in the law that makes sense if you can understand it. And even though we've been doing this for over 40 years, all of us together and separately as a legal team and individually in our various areas and clients, it's important really to get that kind of education. And I think that's really, really important. So I want to make sure that everybody here understands, you know, just filling out the forms is the beginning. Having the information correctly and knowing where to get it is part of the process. And then when you have all that, you can see a little bit of a behind the scenes view as to what actually happens back and forth. So I want to thank everybody for attending now. We're going to take questions and answers right now. I think Anatoly may have some, but as we're doing that, please complete, if you possibly can. I think we've got, let me just double check on the hosting here so we can get the host back. Please, let's see. Ask a question. I want to ask you a question that I'd like you to respond to. I do this at every seminar. Do you think that when you extend credit to your customer, that you're a secured creditor or an unsecured creditor when you sign your contract? So without talking specifically more, we'll see how many people answer that question. All right, just say yes if you can answer the question of the poll. Yes, I am a secured creditor, just yes or no. And I'm curious how many people think they are or how many people think that they're not. And then I'll tell you the answer when we're done with the questions and answers. Anatoly?
Perfect, thank you. We just got a few minutes left for a Q&A, so I have a few questions here. I think this one was actually addressed already. Laura Gill asked, can you explain when a preliminary notice needs to be sent out? And this is for Texas and New Mexico.
She wants to know when you can send the notices out for Texas and New Mexico?
Mm-hmm.
Okay. Well, it depends on the three questions. What state are you in? Is it public, private, or federal? And what is your role in the job? So, you know, we can talk about everybody's role, but it would take a long time to do that. So I would suggest that, Laura, what you can do is go to the website initially and look at the resource page and sign up for the Texas and New Mexico questions. And then you can take a look because that explains that if you're a GC, you have a longer time period than if you're a sub and a supplier. So, you know, we'll be happy to answer that more specifically. I just don't want to guess at it, and I don't want to give the wrong answer. So I need to know that other information too. But Texas does have what's called continuing notices, and everything in Texas will be like today's the 17th. If you have a problem in Texas right now, you don't have to worry about that until the 15th day of next month, because that's when all the notices go out. So you've got almost a month to get the answer to that question if you have a problem or want to know more information. New Mexico, I just don't remember right now, so I don't want to guess.
Perfect. So next question is from Lupe Paez. If we, subcontractor, are finished on a job, but job is still ongoing, we bill retention and our 90 days are approaching, we're in California, can the contractor claim to not be able to pay us because retention hasn't been released due to the job not being completed? Should we file lien or are our hands tied because contract states we're paid when owner pays GC?
That's kind of a legal question, so let me just answer that quickly. Every subcontract, if you allow the general contractor to do it, will include a contingent payment provision that'll flow down sometimes to suppliers or subs. The fact that you have a contingent payment provision in there, as you're mentioning, that you can't get paid until they get paid, does not mean you cannot file a lien. In fact, you should file a lien, particularly these days, because we're seeing more and more contractors not paying the retention, and some of them going out of business and having problems. I mean, in the pandemic, if you were doing restaurant improvements, hotel improvements, exercise improvements, event centers, all different kinds of medical facilities that were shut down, you saw a lot of problems going on. So we recommend that you file the lien, file the statutes. I mean, if you remember my first statement, I said to everybody today, NLB has a formula: transaction plus power equals payment. It's something that you have to adopt into your own internal process. And if you do that and follow the steps, you're going to get paid. And you do not let your lien rights go. And secondly, Regina and Josh correctly mentioned about payment bonds being placed up on the projects. But there's also another set of bonds called bonds to discharge liens. That's being used like candy right now. Why? So let's take this example. What state is that in, Anatoly? Did he mention what state that project was in?
So the project is in, they're in California.
Okay. So let's say in California that you lien the job or you didn't lien the job. So if you don't lien the job, you don't have your money. If you lien the job, the general contractor will still try to want to get his hands on the money with you sometimes, because he'll file a bond to discharge the lien. And when he does that, okay, that's different than a payment bond. That means your lien is no longer against the property. The owner pays the general contractor and he's got your money. He puts it into the bond and hopes you don't ever call him again. And when the bond, when the time period runs, to file your lawsuit, which I think is 6 months in that situation, from when the bond will be posted, then I think at that point, you're in a situation where you're out of luck, because basically you have no bond claim anymore and no lien claim. So even though it's easier to make a lawsuit against the bond, practically speaking, we don't like to see that. And that tactic is something that we're looking at strategic ways to get around. We're working on that right now with a new strategy, which we can talk about in future seminars.
Perfect. So then going back to your question of secured lender, not secured lender, the overwhelming majority seem to think that the no is the answer. They're not a secured lender. So I wanted to see if you want to touch on that a little bit.
Yeah, that's why we have these seminars. Actually, when you extend credit in construction, by statute, not by agreement, you're automatically a secured creditor if you perfect your lien rights. So I kind of get a kick out of asking that question for the last 40 years. It's even it's funny now, it's funny back then, that we have this misunderstanding that you have to do something right away to become a secured creditor. All you need to do is follow the steps from the pre-liens to the lien claims to the lawsuits. You follow those steps, you are given the right as a matter of statute. Typically, a secured creditor is determined two ways. So if you were doing, let's say, a commercial loan, many of you borrow money on your commercial line of credit and so on, your companies do, then you pledge as collateral your personal property, your receivables, and things of that nature. So when you do those kind of things and you secure yourself, you're signing what's called a security agreement, granting a security interest, thereby making the creditor, the bank in this case, secured creditor. Many suppliers have to have security agreements with their subcontractors, and we recommend that now. That's one of the strategy techniques we want to talk about instead of doing liens alone, is developing that situation. But in a mechanic lien scenario, you're given as a matter of right the ability to file a lien by law. Nothing needs to be signed. And you have to be careful because if you don't follow the steps or you sign a waiver or release of lien or waiver of lien, as Regina was mentioning before, and Josh knows, if you sign those papers incorrectly, then you're giving up those rights that you otherwise had because you let the waiver show that you've been paid when in fact you haven't been paid, what's typically called an unconditional waiver of lien.
Perfect. That covers about all the questions that we currently have.
Okay, very good. All right, so thanks everybody for attending. I'm sorry I couldn't answer the New Mexico one off the top of my head. I want to look at it. I don't want to give the wrong information out. But if you go to mechanicslien.com on the website under resources, you can get your initial questions about what the time periods are if you're a GC, sub, or supplier. It's a public, private, or federal job. But more importantly, just call the 800 number, 800-432-7799 or info@mechanicslien.com, and we'll get right back to you. We enjoy talking to everybody. I want to give an announcement. You're going to be invited to learn a little bit more about a new exciting way that you can find, fill out your project data anywhere in the United States and get the information. So look for that information. And thank you again for attending. And we're here for you anytime you need it. And remember, look the developer in the eyes and tell them, please pay me because I don't want to become a developer and take away your property. Thank you.
Perfect. Thank you, everyone. And we'll be circulating a recording of this webinar. Thank you to the panelists for participating and sharing your knowledge and insights. Thank you, everyone, again.
Thank you.
Thank you, everyone.
Thank you.